It has been an extremely long and hectic day for us at ThePrint, tracking the P. Chidambaram case with CBI and defense lawyers of P. Chidambaram fighting it out in the court for P. Chidambaram's custody by the CBI. So finally, the custody was granted by the court. He'll be in CBI custody till 26th of August. So ThePrint was at the court, at the special court at Ross Avenue, CBI tracking all the arguments that were taking place between CBI and the counsels of P. Chidambaram. So ThePrint, what was the highlight of the day when you say that about, I mean, this hectic day wherein the hearing went on for about hours and TV channels running it continuously and everybody just keeping a close watch on it?
So I think the highlight of the entire day was the unprecedented act of Judge Ajay Kumar Kohar to allow the former finance minister to speak in the open courtroom, because we all are aware that when an accused or even a member of the prosecution is not allowed to speak in court. But when Mr. Kapil Sibal and Mr. Dr. Abhishek Manu Singhvi requested the judge that the former finance minister wishes to put a point forward, he was allowed, even though Solicitor General Tushar Mehta vehemently argued against it. And he said categorically two things which are very important for us at the live to discuss is that first, the judge should look at the transcript of the interrogation that happened on June 6, 2018 by CBI. And secondly, what were the questions that were asked to him? So he basically maintains that there was no material questions that were put forward to P. Chidambaram.
Right.
Now, what we draw from here is that, ThePrint had accessed the order copy, the 10-page order copy by the special CBI judge. And one of the most important points the judge notes is that even though this argument was made by Kapil Sibal and Abhishek Manu Singhvi, the senior counsels, that he was interrogated only once last year and not once was he called. In spite of that, he notes and reiterates that such a crime involving such huge amount of money, which me and my colleague had yesterday discussed, involving about 305 crores, necessitates a detailed interrogation, and that is why the CBI comes into the picture and the CBI custody comes into the picture. So, this was the highlight of the day. We can go into the details as we move along.
In fact, this has been the CBI's claim even yesterday and while opposing the bail plea that was filed in the court, that it's a case of monumental magnitude and a lot of money is involved in it, which is why the interrogation of P. Chidambaram is absolutely necessary. In fact, the defense of counsel of P. Chidambaram has been mentioning that he was not even named as an accused in the FIR, which has been the basis of their entire argument, that he was not even named as a suspect. Then why do they want to arrest him and then interrogate him and arrest him in such a manner, it was such a dramatic arrest that
scaling the walls.
Exactly. So why was it so important to arrest him? So that has been their argument. In fact, at CBI headquarters, from where we were following the case, till about when Chidambaram was taken to the
late
court.
Night,
till about he was taken to the court today for his appearance in the court. He was interrogated for about 4 hours, and but from what the information that we've got is that he was asked only 12 questions and essentially confronted on Indrani Mukherjee's statement that she had paid about $1 million to his son Karti Chidambaram to get that FIPV clearance. So ThePrint, in the court today, our viewers would want to know basically what was the defense's argument on this entire case. I mean, what did they base their arguments on when it came to this?
So just before going to what Kapil Sibal and others spoke about in this entire case, it's also important to know that how Solicitor General Tushar Mehta began the case, and it's very interesting, Ananya, because he says that right to silence is a fundamental right. But right to being evasive is not a fundamental right. He says that, when we are asking questions to the former finance minister, he is not an illiterate person who does not understand what is being put forward to him. Absolutely. He is in that capacity to structure his answers and answer the court accordingly. And hence it becomes imperative on part of Mr. Chidambaram to cooperate with the investigating agency. Not doing that, they say that the former finance minister was not answering the questions. He did not remain silent. Solicitor General Tushar Mehta said this. He did not remain silent, but only answered questions which were not right. Now, Dr. Abhishek Manu Singhvi argued that you were asking me what the defense argued. The defense primarily said that how can you define an answer as a correct answer or a wrong answer.
Right.
Because this is something which is within the domain of the court to do. The judiciary will look at whether the answers were not right or right. The CBI has to be only bothered about the answers.
Yeah, and record them as it
yes,
is.
absolutely. So, Dr. Abhishek Manu Singhvi and Kapil Sibal goes on to show a plethora of cases wherein said, wherein the definition of evasive has been defined, and they go on to prove that how the former finance minister P. Chidambaram was not evasive while answering. However, also important to note is that the 12 questions that you just said.
Yeah.
So, Kapil Sibal and P. Chidambaram continuously, argued in court that they must, the prosecution must, mention before the court what were those 12 questions. They wanted to prove by this point that those 12 questions were immaterial questions which did not lead to the INX media case. However, the Solicitor General Tushar Mehta obviously stuck to his ground and said that any well-knowing and research-oriented and very cautious investigating agency will not tell the court in an open courtroom what those 12 questions were.
Exactly.
And those are the chronology of events that they seek to establish by unrelated questions.
In fact, they went up to the extent of saying that the CBI was not prepared to question.
Yes. Which I think Mehta, Solicitor General Mehta only said that we will not be answering in the open courtroom. We can give the case diary to which they also did. They gave the case diary to the honorable judge and said that they can peruse over the matter. But again, coming to the order that just happened a couple of minutes back, the judge has indeed noted all of this. The judge in its 10-page verdict has noted what the prosecution said, what did the defense say, and there is also a point when Abhishek Manu Singhvi said that we are talking about a monumental magnitude crime for which the punishment is only up to 7 years. So he went on to correlate that a gravity of the offence is always related to the punishment it entails.
Absolutely.
However, the judge has noted that this argument cannot be accepted in the court of law when such amount of money is involved, which also Ananya goes on to prove that CBI was talking about this case being of monumental magnitude, has got a seal of affirmation by the special CBI judge also when he says that such a crime of such amount of money necessitates a deeper interrogation. So I think trouble's ahead.
We have a question here, Debayan. Shiva is asking what happens after the 5-day custody. So I think according to the procedure, they'll be applying for bail soon.
Yes, we were all expecting that there would be a bail today, application today, but it was not made. And this bail application can be made even tomorrow, and even tomorrow is the only day, and then Monday morning also it can be made. But let's not forget one thing, that he'll be now produced in court after a medical examination. This is mandated. The court order also mandates that his family members and legal counsel will meet the former finance minister for half an hour every day.
Okay.
So that is a part of the order. Also, let's not lose focus from the plea which is before the apex court tomorrow.
Yeah.
So Justice Bhanumati and Justice Bopanna will preside over the 2-judge bench, which will hear the plea that was filed by the former finance minister yesterday, which was not listed by the registry. However, it is very important for us at ThePrint to tell all the viewers that it was being said in the media that the application before the Supreme Court has now become infructuous.
Yes.
But let us all clarify that the plea is not becoming infructuous. It is only partly invalid now because the former finance minister was seeking protection from arrest from ED and CBI.
Which any day happened.
Yes, the CBI arrested the former finance minister, but the ET has only issued the lookout notice, if I'm not wrong.
Right.
Yeah, so the plea survives on the basis of enforcement directorate and is not completely infructuous, so the hearing is set to take place tomorrow.
Okay, so basically it is that now CBI has his custody, but if ED wants the custody, then...
Yes, absolutely.
Yeah.
But legally speaking, it's very difficult for the Supreme Court at this stage to intervene and cancel the bail application or dismiss. It's very difficult for the court to go ahead and uphold this plea filed by the former finance minister, considering that the lower court already had elaborate argument session today in the trial court and granted him custody in the CBI case. This ED case can be looked at a later date, but obviously interim protections are well within the boundaries of the Supreme Court, and it's especially petition under 146. So the court can grant him interim protection from ED, but let's not lose focus that CBI court can grant police custody of 14 days at a stretch.
Yes.
So out of that, 5 days or 4 days will be over on August 26th.
Right.
Now again, if they reapply for, let's not also to recollect, Ananya, during Karthi Chidambaram's case in the similar matter in INX media case in the Patiala House Court at that point of time. the judge had granted 11 days custody in the same case.
Yeah.
So, and I think the charges against the former finance minister are a little of higher magnitude because here the question is about influencing the government.
Right.
Something that I wanted to talk about today also is that how the prosecutions, the defense had put forward a very interesting argument, Ananya. They said that there were 6 secretaries in the FIPB, right, who granted the approval to the INEX media.
Yeah. So it was not just Chidambaram, 6 others.
The 6 secretaries,
are also
they only recommended this to the former finance minister after going through all the files. And the court noted, Mr. Sybil said that none of those 6 have been arrested or questioned. Dr. Abhishek Manu Singhvi goes on to make a statement that it might be possible that some of them are a blue-eyed boy of the government. But also a very important fact that we have already flashed at the print is the defense counsel also stated that one of the members among the FIPB secretaries have gone on to become a RBI governor. So, they try to draw a link to that. Again, the court has noted in the order as well.
Right.
But I think, Ananya, these are all questions of merits which will be taken up at the trial, of course. But at the pre-arrest stage or the pre-charge sheet stage, these arguments don't matter much because I think that is why the case for Chidambaram collapsed today in the trial court.
Yeah, in fact, that's what they have been saying. Like you said, these 6 secretaries, they've never been arrested or even called in for questioning. Then why Chidambaram?
Why?
In fact, they also mentioned yesterday that in 2018 there was just one summon that Chidambaram had gone for the questioning. After that, there has been no summon.
No questioning.
Yeah, so if there is no questioning, then where does this entire thing about the arrest
There was
comes
also
from?
this delay part, which the prosecution tried to prove, the CBI tried to prove that Mr. Chidambaram was under the protective umbrella of interim protection from the Delhi High Court.
Yes.
But I think Mr. Sybil refuted it by saying that there was a 7 months delay in delivering the verdict on this anticipatory bail plea, which was delivered on August 20. But they said, were the counsels aware that there will be a 7 months delay? No.
Yeah.
Did the judge know that there will be a 7 months delay? No. Then on what basis, on what ground is the Solicitor General accusing the defense of having a protective umbrella of 7 months of interim protection?
But does this stop the agency from calling him for questioning even though he has this interim protection?
No, absolutely no, because just to reiterate my point, when this order was passed saying that he'll have the interim protection, it was also taken as an undertaking that Mr. Chidambaram will cooperate with the investigating agency
and there'll be
in
no
investigation.
Coercive action.
Yes, no coercive action. That essentially means arrest.
Exactly.
That there will be no arrest. So if you're being called, you come and answer my questions. Now the entire premise of CBI is that they did not call the former finance minister in the entire last year for any questioning. And today, this year in January, when they sought that questioning for questioning we need custodial interrogation. So at that point of time, the judge reserved its order and delivered the verdict 7 months later. So that was the entire scenario that cropped up.
Also, to add to what will happen after 5 days custody, one, as you're saying, that a bail application can be put up either tomorrow or on Monday. Also, he'll be sent to judicial custody if in case the court doesn't grant an extension of police custody for Chidambaram.
Yeah, judicial custody is the next step. It's the next step because again the CBI has to.
Yeah.
And again, let's not forget that a case for judicial custody is much more difficult than a case for remand.
Absolutely.
Because when today Dr. Abhishek Manu Singhvi pointed out the 3 points that there is no flight risk, etc., etc., the Solicitor General Tushar Mehta intervened and said that we are only going to talk about this at the judicial custody stage, not at this stage. So that is obviously there is an option for them to seek, but there is also a very crucial juncture for us to look forward to the Supreme Court tomorrow as to what the 2-judge bench says. They have their in their right to uphold the plea and bar ED from arresting or taking any coercive action.
But what we also hear from CBI is that they'll be pushing for more custody because 5 days they said was not enough.
Yes.
So that could also be a possibility. So another question that we have from Ravi Shankar is what prevents him facing the case head on? Why all this unnecessary drama? We have been talking about this drama being entirely unnecessary because scaling the walls and going inside because he anyway did come to address the press. He did come to address the press. He was at his home with his lawyers inside. So there was actually no need to scale the walls and get inside.
Basically, Ananya, what happens here is that though an interesting point, but then CBI before, in the morning when they went, they only had the Delhi High Court order, right? So they served the notice. But this time in the evening when they went, they had a non-bailable warrant against the former finance minister from a special CBI
Right,
court.
right.
So I think that
That's
gave
good.
them all the muscle to scale the wall and then go ahead and arrest him, because
Yeah.
that is the go-ahead for all the investigating agencies. So I think that is the thing. But also we now need to look
Yeah,
at
there might too many.
what happens.
Yeah.
Too many questions
Too
are
many
there,
questions,
but
but
then
we are
time.
running out of time.
Yeah.
So we'll be doing this soon. We'll be taking more questions on this. It's a very interesting case and a developing case, in fact.
Yes.
And tomorrow also is going to be an important day. So we'll be back with more information, and then we'll be taking your questions. This is Ananya Bharadwaj and Debayan Roy from ThePrint.